am grateful that I have here to discuss defense attorney and former head prosecutor Bob Bianchi. Bob, now there are a few things that are really driving me crazy. One of them is the form of the questions they're asking. They're objectionable, and it's on both sides. You had it during the cross-examination. You also have it during the redirect. They're drawing all these objections. The jury's sitting there listening, by the way.
Yeah, I mean, you need to be careful, Judge. We've talked about this many times before, that as important in my mind as a trial lawyer, it is to know your facts better than anyone else in the courtroom, to anticipate legal issues and evidential issues ahead of time. So you're the person there that can cite the case and give the judge a brief. That's that polish and shine. So that when a judge is making a decision, for example, they're going to look at you as a more trustworthy font of information if you're prepared. So too with the jury. The jury is looking at everything. They see everything. Their 12 minds that are going to ultimately deliberate here are far greater and collectively than any lawyer could possibly be. So you need to be on your P's and Q's. And part of that professionalism, so that they have confidence in you, so that they trust you, so that they agree that you're giving them information that's untarnished and something that they can believe in, is to ask questions in a professional manner where a judge is not rebuking you continually, because that shows that you either don't know what you're doing or that you can't be trusted as a source of the best person in the courtroom. So when I try cases, I try to make sure that my questions are tight, they're to the point, they're not legally objectionable, and I want my adversary to be saying objection, overruled, objection, overruled, objection, overruled. It's basic 101, because many times we know, Judge, that jurors will leave that courtroom, and it's a human endeavor. And I always tell my people when I train them, and you've trained together, lawyers, it's not what you say, it's not what you do, it's how you make people feel. The old Maya Angelou quote. And that is exactly what I want the jury to walk away with. You know what? I'm not sure why, but I trust that guy.
But
that's not happening here.
Yeah, because you don't want to waste the jury's time. And when you are getting all these objections sustained, you're ending up wasting the jury's time. One other question while we have time. Is this relevant, this testimony, to the basic allegation that this woman conspired to kill her own husband? This is day 3 of the sister's testimony, and I'm listening, Bob, and I'm thinking, have they gone too far? Is this even relevant at this point?
Yeah, great point, Judge. I was going to actually ask you a rhetorical question back, which I know is not a proper format, but you're
I know you, so I'm good with that.
Well, you know, I'm asking myself the same thing. You've proved beyond a reasonable doubt that this was a relationship that was awry, that there was an insurance policy. That describes about maybe 50% of the populace that's out there. And as a former homicide prosecutor, I've had the dangling, you know, the shiny object in front of me, that a contentious divorce and things that could make it appear that there's motive. But that motive has to be substantiated with facts and not just completely circumstantial in my mind. Motive's not necessary, obviously, as an element of the offense, and you want it as a prosecutor, but you want to be able to support that with actual hardcore facts. My biggest question I have in this case, I think by the prosecution trying to do all this character assassination may backfire against them, because as a defense lawyer, I'm saying that's all they got? That's all they got. That's all they could deliver to you. Now, here's the big question to me, is the guy who pled guilty without an offer to testify against her. What's happening with that guy? Yeah,
and he had last said she wasn't involved in it. All right, I know we need to take a break. That's defense attorney, former head prosecutor Bob Bianchi. Bob, tell me what you think of this information that the jury's receiving, because it says a lot about Mr. Baker, but does it say enough about Monica yet?
My observations were, number one, I wrote them down in order. I'm glad that I took espresso before I came on the show, because I think I may have nodded off based on the lack of data that was coming through here. Number two, this guy is like at a central casting for a TV show. He looks the part up into the divot in the tie. I wish I had his hair. I used to a long time ago. My life would be completely different. But unfortunately, I think you want me to give you a legal opinion. And my legal opinion is, Judge Ashley, that this witness is doing nothing to drive the mission forward. It's focusing on a co-defendant who's already pled guilty, who supposedly is going to potentially come in and exculpate or exonerate the defendant that's at trial at the hands of the prosecution, who had the ability to have him testify truthfully and favorably on their behalf in exchange for the plea, which apparently did not occur here. So a lot of this is very confusing to me. And I'll say one last point. You know, I always like to give a style tip. And my style tip with the prosecutor is very interesting. She clearly is experienced. She knows how to ask direct examination questions in a very tight and formulaic way. So I like that. But the intonation of her voice is such that you always anticipate the killer question is coming that's going to lead you to the aha moment. Is it a fact he got onto the bus? And is it a fact you saw him get off the bus? And is it a fact you saw him get into the cab? And is it a fact? And you're like, oh, what's next? There is no next. So I don't know. I'm not feeling it, at least from a juror point of view. And like I said before, Judge, I think if the jury keeps listening to more and more of this, they're going to say, as they used to say in the old times with the commercial, where's the beef?
Well, and the other thing is, Bob, all the things that you shared that entertained me, it may be what the jury's thinking. They may be so bored with this or wondering where's it going. They're thinking about his nice hair or what he's sitting up there doing other than listening to testimony, because that's the reality. The jury could be seeing it the exact same way. I have to tell you, really quick answer from you, Bob, but a little tidbit. This morning there was a juror who fell asleep, and that was the report by the other jurors. The judge questioned him. He said, oh no, I'm closing my eyes, but I'm listening. And the judge said, well, I think I disagree, and he was excused.
I had an exact situation like that in a murder case I tried, where I tried to get the juror thrown off, and I'm like, Judge, she's clearly sleeping, she's nodding, and the judge refused. I think she's just thinking. People do that, and wouldn't let her stay on the jury. In the end, she convicted the guy, so the judge's like, well, I guess you would have excused the juror that was on your side. It's crazy. Yeah,
it is crazy, but to the point, I think it's good the judge did excuse out of an abundance of caution, because you need your jury alert, paying attention. Bob Bianchi, thank you so much for joining me today.